We now move to the race between Richard Dietz and Vince Rozier. I will say Judge Rozier has sent a message to us saying that he could not make it today. I have a statement to read on his behalf in just a second, which I guess is now because he will be first up in that particular race. Vince M. Rozier, Jr. is a current district court judge in Wake County. And his question was as follows. North Carolina's economy has diversified over the past number of years and has become increasingly international in scope. To what extent do you believe that the law of other jurisdictions should be utilized by the appellate courts in the interpretation of statutes or in the adjudication of disputes over the common law in situations where there may not be a clear answer based on North Carolina law alone? And I've gotten a lot more emails since then than I was expecting to have gotten, so where did he go? Here he is. All right. I am sorry that I'm unable to be there with you today. As a trial court judge, however, there were matters set to be heard by me today. Those families are not concerned about the Court of Appeals, but about having a resolution reached in order to move forward. I've been a district court judge for over 10 years. I was nominated by the attorneys of Wake County to serve and thus became the youngest judge in Wake County history at the age of 29. Before that, I worked as a Wake County prosecutor. As Vince Rozier, the prosecutor, I tried nearly 70 jury trials, which included everything from drug trafficking to armed robbery to murder. After becoming a judge, I served as a family court judge for over 2 years and been certified as a family court judge and juvenile court judge. I preside over felony pleas, DWIs, and probation violations. I believe in following the law and holding everyone responsible. Now I'm running statewide to be Judge Rozier of the North Carolina Court of Appeals. The Court of Appeals primarily reviews matters from our trial courts, so it makes sense to have judges who have judicial trial court experience. But only 3 of the 15 judges at the Court of Appeals served as a trial judge before serving on that court. We need judges with a variety of experiences. I have the criminal, family, and juvenile to add a missing perspective and experience, presiding over 70% of the types of cases that are heard by the Court of Appeals. I'm not thrilled about the politics of running statewide, and I offer nothing negative about any other candidates. I simply believe that the perspective that I would contribute to the Court of Appeals is missing. Having grown up in the Tar Heel area of Bladen County, I worked on tobacco farms and learned the value of hard work. I graduated valedictorian and received a full academic scholarship to UNC Chapel Hill. I'm the author of 2 books. I believe in following the Constitution and the law. I ask for your consideration and your vote. Now, in regarding the question on how to utilize case law or jurisdiction from other jurisdictions, of jurisprudence from other jurisdictions to resolve issues of first impression, let me say, having had the opportunity to travel to the country of Jordan and observe how their system of government works, I understand the significance of this issue. I believe that in matters of first impression or issues where the case law has not been established, that it is appropriate to consider how other jurisdictions have handled similar issues, beginning with those within the Fourth Circuit. Of course, when looking outside of our jurisdiction, it is important to understand whether the statutes in other jurisdictions are identical with comparing the relevant case law. With issues that deal with the growing economic diversity of our state and nation, yes, it is appropriate to consider what has come from within the Fourth Circuit or from other jurisdictions. I also believe it is important to take time to understand what is happening within the business courts in North Carolina. The business court has its own role to play in answering this question. While the business court in North Carolina is comparatively young when compared with the other levels of court, there is still a legal culture that has and is being established. Appeals from the business court now go to the Supreme Court, but I think that it is important not to disregard what is taking place there. It is important to understand that issuing opinions may make sense to another jurisdiction, but could have collateral consequences within our own. This is also an example of why it is good to add to the perspective of judges on the Court of Appeals who regularly deal with everyday operations of North Carolina courts. Thank you again, and I apologize for my inability to be there with you. So that's the message I got from Judge Rozier this morning. And now we will turn to current Court of Appeals Judge Richard Dietz. And here is the question for Judge Dietz. Now that you have served on the Court of Appeals for a time, you have had the chance to author a number of opinions, both unpublished and published. Since we as both lawyers and lawyers and voters often look to authored opinions to help us understand the judicial philosophy of a particular judge, please give us an example of an opinion you have authored which you believe should persuade us that your candidacy is one we should support, and explain why. Judge Dietz.
Thank you, David, and good morning, everyone. I'm Richard Dietz, one of your Court of Appeals judges, and thank you all, not just for having us here, but for the format of this forum, because we do a lot of these forums, and usually we all get the same question, which is, what are your qualifications to be a Court of Appeals judge? And I could stand up here right now and not only do my own, but everyone's sitting here also. And so I've enjoyed being able to listen to the different questions that everyone has received, and so I'll give you a real quick background, but I want to mainly talk about my question. I think it's a great question, but I've had a lot of success in my legal career. I was first in my class in law school at Wake Forest University. I clerked for 2 federal judges on the Federal District Court and for Emory Widener on the 4th Circuit. I worked for a time at Covington and Burling doing both a combination of insurance coverage and U.S. Supreme Court work in D.C., and then I moved back to North Carolina, became a partner at Kilpatrick Stockton, spent most of my career at that firm handling civil litigation in the trial courts, but also in the appellate courts. I have argued a lot in the State Court of Appeals, in the State Supreme Court, in the 4th Circuit, in every other circuit court in the United States except I think the 6th and the 8th. And I've stood and argued cases in the U.S. Supreme Court. You can Google my name. You can see courtroom sketches of me standing in the U.S. Supreme Court arguing cases. And I'm the only board-certified specialist in appeals on the 15-member Court of Appeals and the only candidate. So I've got the experience, but let me answer the question. So I think I'm up close now to 200 opinions. And I know, so part of the trick of this question, I think, was forcing me to just pick one. You always want to just say, oh, read all 200, right? But I picked one. And so the case is Times News versus Alamance Burlington Schools. And so the facts in the case are really straightforward. So you have a school superintendent who had just signed a contract to stay on as school superintendent for a number of years. And then just a few months later, the elected members of the school board, they have a meeting and they go into a closed session. And they come out of the closed session and they say, the school superintendent will be leaving the school system. And the school system will be paying the school superintendent several $100,000 in severance. So as you might imagine, the Times News, which is the Burlington newspaper, wants to know what the heck happened in that closed meeting, and why is the school superintendent, who had just signed a contract to stay, now leaving, and why is this school superintendent getting paid all this money? But the rub in the case was there's a lot of tension between the public record laws, which have this really robust protection for school personnel files and the records of school employees, which includes the superintendent, and the open meeting laws, which are more flexible in certain cases, allow judges to say, well, it happened in this closed meeting, but I think in the interest of the public should know what happened there. And the reason I picked this case, I authored the opinion, it was a unanimous opinion, that held that if the words coming out of the mouth of those school board members in that closed meeting were the sorts of things you'd find in the personnel record, then you can't disclose it. Because if you could, it would just end run around the legislature saying you can't ever disclose what's in the personnel file of a school employee. But all the other things that might come out in that closed meeting, like, for example, what the school board members were talking about when they're deciding on the severance package and what it may mean, politics, policy, any of that has to be disclosed. So we remanded and instructed the trial court, do an in-camera review, separate out what can and can't be disclosed. And we, a very short opinion, I think less than 10 pages, explained exactly what should happen and said in future cases, we'll expedite these appeals because we want to make sure you can't unring the bell. So we'll hear an appeal if there's a dispute about whether it should really be released or not. The key in this case, though, is that the opinion that I authored, which later folks on the school board side of things and in the press saw me and said that was a great opinion, that was the right result. Neither party argued in their briefs for that result. And I think you all probably are not that surprised by that. I'm not that surprised by that. I was a civil litigator like you. I know if there are several reasonable interpretations of the law, and there's one that's really good for your client, that's the one you're going to be arguing in your brief, right? That's your job. And the same thing for the other side. And what good appellate judges have to be able to do is look at those arguments and look at the jurisprudence, the law of our state, and say this is where the right result is. And my concern is if you don't have that experience over many, many years of studying the jurisprudence of North Carolina, there's a temptation to just say, I agree with this side, not this side, and I have a roadmap right here in this brief of how to write the opinion, and that's exactly what I'm going to do. And as I travel around the state and really dig in to what lawyers and also the public have to say about the Court of Appeals and what they don't like, the most common complaint that it comes back to is, well, they didn't get my argument, and they just adopted everything the other side said, and now the law is all messed up. And that's the one commitment I will give you, is I spend the time to get it right and to chart the right course, even if it's not exactly what either party argued in their briefs. So thank you all again for the opportunity to be here, and I hope I can count on your support in November. Thank you.
Thank you, Judge Dietz.